Bergeron, 2352 South Kaufman Avenue. I have several questions concerning this rehearing. First of all, you cited a statute. Could you recite that again?
Chapter 10, Section 1P of the zoning resolution.
So that's not a statute, it's just a zoning resolution?
That's correct. It's a Section 1P of the zoning resolution.
Okay. How did this process occur? Did you just spoke before the work session and asked to bring it up, or?
No. Chief Tyler gave me a call, and I visited with him, and we had a conversation. And in that conversation, some changes were offered, and at that point, I approached Bill, and we talked about how the process moved forward with the reopening.
Okay, thank you. Another question that I have is, as I heard what you said when you made the motion, I only heard ZC 14002.
Let have a copy. One copy of the resolution. Or the amendment.
So it's only 002, it's not 0CZ 12001. Is that correct?
It's both online.
Get your shit together, boys.
I looked myself, but my computer just lost what I brought. Could I have this, or could you email me a copy of this draft?
You can have that.
And you have a copy of the agenda?
Yes, I do.
Okay, it's on there too.
But when he stated it, he didn't say the second item. He only stated the first. And in this draft, it only says the first. That's my question. And you only voted on the first.
What was your question?
I'd like an answer to my question.
And what was your question?
When Matt Keating brought forward the motion, it only mentioned in the motion and on this page, ZC 14002. Is that the complete motion?
I believe that is correct, and I am thumbing through. But I still get something that I just reviewed a few minutes ago.
Mr. Chairman, if I may, I think there's just a misprint on the agenda. That was a ZC 12 would have been a zone change application from 2012. So the only thing that was made for the motion from Mr. Keating was the 14002.
Okay, so that's what they voted on, correct? Okay. And then as far as can I go on, or are you still?
Yes, continue.
Okay. As far as when this proposed change will be available, I'm not understanding the process here.
Correct. Understanding there will be a new staff report developed.
Needs to go back to planning and zoning and then back up.
Coincident with the filing of the budget, or the rehearing, the formal advertising of the rehearing, and that will be available at that time.
And then there's 14 days after that before the actual hearing,
Right.
correct? Okay, and will this halt any future process until this hearing?
There's no process that's going on right now.
Okay. Okay, nothing changed.
This will reopen the process that was closed last week.
Okay, and when you send out your notices,
Yes.
how is that worded? Is that worded saying new evidence? Does that tell the public what the evidence is?
There will be
Those people
notification.
notified.
That's right. People will be notified that there will be a new hearing to discuss only new evidence on a meeting to occur in these facilities on the 15th of July.
And what
I
I'm
presume that there will also be a reference as to what the written staff report is.
perfect. Thank you very kindly. Yes.
E14-2, please approach the lectern.
They'll never see the air hate waves.
My name's Paul PAAD, 2781 Cherokee Lane. I think I'm going to take a little different approach here than what you've been hearing so far. Mr. Chairman, a month ago, when this was brought back before the board, then Chairman McDowell said that tonight we would be discussing just this new evidence. This is what we're looking at tonight, just the new evidence. So that's what I want to try to concentrate on here. New evidence, as described by our county attorney. Part of it, I didn't get the exact wording, but part of it was basically it was something that could not be found by using due diligence. Is that, correct me if I'm wrong. I jotted down the five things that Mr. Tyler listed as new evidence. Number one was the concerns of the residents. Now, there was concerns 2 years ago when they were rezoning out there. Does it not seem like due diligence would have been going out and kind of checking with the residents before they put in the zoning application and try to resolve some of these issues in advance? He said the petition was new evidence. Had he done the due diligence of checking, seeing, testing the waters with the area property owners, I don't think that petition would have been a surprise. I've been told that they've even almost doubled the number of signatures on that since last week. 98 land use plan, he offered as new evidence. This seems like that if you're going to develop an area, you might want to know what the land use plan was for that area. That's not new evidence, at least not my opinion. History of the zoning in the area. Again, you have an experienced developer. This due diligence gives you all of this. This does not fall under, in my opinion, does not fall under or meet the level of new evidence. The other thing he listed as new evidence was the benefits of this industrial park. Is he going to stand here and tell this Board of Commissioners that when he first presented before you, he had no idea what the benefits of this were going to be? That's not new evidence. He should have made that argument then. Okay, so I guess based on those 5 points of new evidence that he presented, I just honestly can't see what really is considered to be new evidence. Again, my opinion, but that's the decision that you as board members have to make. A couple of things I wanted to touch on. First of all, I'd like to thank Commissioner Wanger for showing up at that neighborhood meeting. I thought it was at least showing a little interest in what was going on out there. Some of the things that come up during that meeting, talking about the enforcement of these covenants, and when the residents ask, well, gee, if you get a business in there that doesn't abide by them, who enforces it? He says, well, it's between the park and the owners. It's up to those owners to go get an attorney or come to you, is what he said, or basically try to enforce them through a court of law. So putting a burden, if somebody decides not to abide by the covenants on these residents and have to hire an attorney and pay for it and go through court and do all that. So, at that meeting, Mr. Tyler indicated that there was some interest in the industrial park already, and he had received some interest. At least twice, he was asked what types of businesses had shown interest in there already. He skirted it, would not answer, he would not give it. He mentioned a couple here tonight, but at that neighborhood meeting, he wouldn't mention. Nobody asked him what businesses, just what types. He also mentioned when they were discussing concerns about the traffic on Salt Creek, he just jumped around and said, well, there's going to be a turn lane out there. That's the first I had heard of that. Maybe it's buried somewhere that I don't know. I guess my question is, who's going to pay for that turn lane? Is it in planning somewhere? Is that part of the permit? I hadn't heard of that before. Okay, if you go to what Mr. Tyler offered as covenants and such, if you look at it, he offered covenants on lots 6, 7, and 8. Lots 1, 2, 3, 4, and 5 had no restrictions placed on it under his covenants.
Yep.
That's, I understand the lots he was using are the ones that border directly next to it, but that's not that wide a piece of property. If you're putting in asphalt plants, or you're putting in somebody that might have storage facilities, he limited the fuel or flammable storage facilities down to 12,000 gallons per lot on those 3 lots up there. There's no limit on it on the other ones. What my next concern with that would be, you have one access coming in there. If you have anything to do with chemicals in there, if you have any kind of flammables, fuel storage, gasoline storage, and we have a catastrophe up there where we have a fire. The fire department's got one way to get in there. Now the prevailing winds are such that they can't come in that driveway, that access. It's going to be hazardous to our firefighters. They already have a bad enough job. Tough, as I mentioned, in less than a week, it seems that they've almost doubled the signatures on that petition. Now I'm going to come to my point of contention on this whole thing. My major point, I guess, is that, as I mentioned earlier, I don't believe we should even be voting on whether or not to approve this zoning change. And if you will, I have copies of the chapter 10, or do you have them in front of you?
No, they don't.
Thank you.
I know we're only talking about one section of this, but I put it on the entire chapter because I didn't want anyone thinking something was taken out of context. What if we go to 10.1p, which is on the third page, which is page 206 of the regulations down above. It's very short, very narrow in scope. It says no application for a zone change which has been denied wholly or in part by the board may be resubmitted for a period of 12 months from the date of said denial, except on the grounds of new evidence or proof of change of conditions. I think we can all agree that I don't think conditions have changed out there. So we have to do this on the grounds of new evidence. And what this is specifically referring to is that if there's new evidence, you would be able to waive the 12-month waiting period prior to resubmission. This is the specific regulation that this was brought before the board under, and it would be my contention that that's what you should be voting on tonight, as to whether or not to allow this to be resubmitted prior to the 12-month waiting period as required under the regulations. I'm sorry, I lost my place here. Okay. Anyway, that kind of pretty much summarizes what I'm at, but I just, since it was brought back to the board, or back before the board, specifically under this section of the regulations, I believe that's the section that you should be following with. I guess the only other thing I'd have, I find it kind of ironic, I don't know, maybe it's just me, but I find a little irony in the fact that Mr. Tyler's seeking zoning change from urban mixed residential to light industrial in order to build an industrial park that abuts up against a residential area on these 29 acres. While at the same time, over on Robertson Road, he's asking for exactly the opposite, a light industrial change, zoning change on 31 acres from light industrial to urban mixed residential so he can build or develop residences right up against the existing commercial area. So I just find the irony in that. So, but again, I really think that we should be considering just what we're voting on here tonight, or what you are voting on. That's all I have. Thank you.
Any questions? Thank you for advice that we absolutely did.
Well, he
Follow
said,
Wyoming state statute.
he explained to you what new evidence, I'd like you to go back and look at his explanation. He explained to you what new evidence actually means, and he explains what new evidence means in a court of law. He said, but this is not a court of law.
That's right.
Now, if I had the money, I believe over that situation, I could sue you and win. Because in a court of law, he gave you what new evidence means. It has to be substantial and very new to the situation. So I would like you to review what your counsel said. I'm sure that
59, which defines new evidence sufficient to have a new trial, is material for the party applying, which the party could not, with reasonable diligence, have discovered and produced a trial.
Bingo.
And I don't know that I can honestly answer what's new evidence or not, but I think one issue that should be pointed out here when we are considering this, and it's your decision to consider that, this is rules for a trial. This is not a trial. And to apply it exactly the same as the court would do, I don't think is the correct application of the law. And for one example, if this were a trial, a person speaking before or against would not have the opportunity to walk up and submit a petition that might go to the hearing, which contains a certain number of names. That doesn't happen at a trial. At a trial, everything that's going to be submitted for evidence has got to be exposed to those other side, usually months